Okay, welcome in. Let's do a sound check. Welcome everyone. How are you? Let's do a sound check. This thing is fighting me. Apologize. Let's do a sound check. Make sure everything's good on this end. Tell you what we'll be doing today. All right. Let's get this together. Come on, man. What is happening with the chat? Okay. Let's see what we have going here. Let's do a sound check. Sounds good. Okay, thank you. Thank you. Computer's being a little glitchy. So if it shuts down on us, I'll start another stream. I apologize. I don't know what's going on. Look, welcome in today. Let's say hello to those who are here before we get on into it, and I'll tell you what we'll be doing. Some of you will like it, some of you will not. All right, let's see what we got here. Carol, welcome in. Welcome in, Carol. All right, Carol's here. All right, and welcome in, Icy Cat. An Icy Cat right there. Good to see you. Welcome in, Icy. All right, so good to see Lisa. Welcome in, Lisa. All right, Rebecca Ann. Good to see you too. Good afternoon. And what's up, Four Pits? Four Pits. All right, welcome in, Pam. And hello, Sabina. All right, and Kayla's here. Welcome in, Kayla. All right. Tracy Fleetwood, welcome in. Have a good drive. Please just listen, don't look. All right. Pam, Tracy, Four Pits, Kayla, Nancy Drew 101. What's up? Welcome in, Nancy Drew, and welcome in for Baby Daddy. Okay. Good to see you. And Bill, welcome in, Bill. All right, so welcome in, everyone. Welcome in, everyone. So what I'm going to do is probably not read the chat for a while. So you guys have at it. Enjoy yourselves. There's a lot to cover, and my computer's glitchy. So I feel like this is far too difficult, but I mean, this is ridiculous. I don't know what's holding me up here. All right, so what we'll be doing today, as you're aware, today is day one of the hearings. Day one of the hearings were Richard Allen's various motions that our lazy judge has delayed for the longest. And she's amazingly only allowed 3 days for this and managed to start late today. So you see how it's going already. But we'll get into that. As far as I am aware, okay, we're working on 10 motions. Let's see if I can get this together with all the glitchiness. Jeez, man. All right. This is a shit show. I apologize. Okay. All right. So first, what I want to talk about is that today we are looking at 10 okay. I want you to understand there's 10 that we are looking at. I want to read through them here. Actually have them on the laptop, so let's do this. All right, so the motions set for the hearings in the next 3 days by our lazy judge are 10 in number, and those are the defendant's motion to suppress, which was filed April 15th. Now think about it. April 15th, it's July 30th. Okay. Motion for admissibility by the state filed May 6th. Okay, it's July 30th. Defense motion to suppress second statement filed April 15th. It's now July 30th. State's objection to defendant's motion to suppress filed April 15th also. It's July 30th. Defendant's motion to compel and motion for sanctions filed April 23rd. It's now July 30th. Defendant's motion to vacate safekeeping order filed May 13th. It's now July 30th. The state's motion in limine filed April 28th, 2024. It's now July 30th. The defendant's second motion to dismiss filed May 20th. It's now July 30th. And the state's response to the defendant's second motion to dismiss filed June 9th. It's now July 30th. So are you seeing a pattern here? Okay. I believe all of this flurry of finally hearing these motions are due to the compelling of the Supreme Court's administration officer who would not do anything about this lazy judge's failure to act. But I think that she finally got the message she needs to do something. So here we are, months and months after these 10 filings, and she's finally hearing them, albeit in a rushed manner, considering that we have very limited amount of time to have all of this done. So what I intend to do is we're going to look very closely at each one of these so that all of you, and I understand there are many people covering this from various angles. You got lawyers giving various opinions. You got YouTube fanatics giving various generalizations. You have the clickbait clout chasers who are just trying to give you the latest photography of Richard Allen entering the courtroom or the lawyers exiting the courtroom. All of this bullshit. You have people trying to be the quickest with the rulings on Twitter who are sitting in there and they're texting their friends. And people have groomed locals for months to try to get people boots on the ground to be able to get inside info. You got people like the Shrek and Fiona who are made sure they were there at 4 a.m. to sit their fat ass in line and be first to get their seat of choice, so that the illegal recording device that she has stuffed up her bra will capture the audio, so that she can go with her unemployed husband, and together they can produce some podcast with a true record for reference, which is the recording she's illegally taken, as she's always done. So you have a plethora of social antics going on around this, but I thought it would be good for us to actually do some basic logical task that can inform us and help us be educated. And no one here is going to tell you how to think. I'm going to give you my opinion from time to time, but just like you, the only way I know anything about what's being decided is to actually read the documents and the filings and the motions, whatever you want to call them, myself. Because by reading ourselves, then we actually know what's being heard. And that's important. Okay, that's important. So before we get started, I'll give you a quick summary of all that we're doing. And then we'll go into, maybe we may cover the top three, say the top three. I don't know. We'll take it as it comes. But so, defendant's motion to suppress. Now, this is regarding the alleged statements made to the state actors and the various agents of the state within the DOC, who we feel basically had been mistreating Mr. Allen and possibly compelling him to give some sort of confession. Because we recall that for quite a period of time, he's made statements to the effect of, is my wife alive? Is my wife okay? Is my family alive? Is my family okay? And those type of statements of concern. which lead me to believe that had he made any prior confessions that were uh, inaccurate and do not match elements of the crime scene and elements that we know about the crime upon these two girls, that what it would actually mean is, in my opinion, is that those confessions were coerced or compelled, and that he's afraid for the well-being of his family and his wife, and therefore, given his concern and his questions of concern regarding his family, that he may have confessed to elements of the crime and that he knows nothing about, therefore they don't match. For instance, saying things like the girls were shot in the back and that they were sexually assaulted. Things like that that don't match the known information about the actual crime. It would be my opinion that if he had no knowledge of the actual crime, uh, as far as the damage or the harm or the attacks done to these girls that led to their deaths, then he would not know how to confess. He would not know what to confess to. So he would be imagining what to confess to, and perhaps imagining to shoot them in the back and to that they were sexually assaulted. Perhaps that would make sense. Okay, if he's reaching. Now, I do believe that at this point he probably does have a better idea of what happened to the girls if he did not prior, because time has passed and maybe people have talked to him. But it appears to me that he was being intimidated. You had, for lack of a better term, odinous guards, who I believe were being quite intimidating and confrontational with him, perhaps causing him or coercing him to these confessions. So, statements uh, we believe were made involuntarily in violation of the Fifth, Sixth, and 14th Amendments, um, and in violation of the Indiana Constitution. So that will be determined. We believe there was psychological, physical, and perhaps some sort of medication-based coercion. Like he may have been medicated to an extent and coerced psychologically and physically, or with threats of harm to himself and his family. So those sorts of things. That's the motion to suppress. Okay, we'll be reading that momentarily. So that's one that is being decided upon, and then naturally you have the motion to for admissibility by the state. Now this wants a pretrial ruling and involves Dr. Monica Walla. Now you may remember that Dr. Monica Walla has gotten herself in quite a pot of hot water, um, and we think it's extremely disheartening and somewhat despicable. She seemed to be extremely entertained by this case and happened to follow a lot of the state-friendly YouTubers. Not only that, Dr. Monica Walla, she was covered by all of the state prosecution-friendly YouTubers. They made quite a concerted effort to attempt to discount the fact that the social media posts that were found were actually made by her. And as you know, as is the case with news, it doesn't matter if it's true or not. The way that these psyops operate and these public relations operate is you just say it. Doesn't matter if it's true or not. Just the saying alone puts it out there, and people will believe it. So immediately when it was discovered that Dr. Monica Walla had been inappropriately interacting on social media around this case, um, the troll farm constituent creators came out lockstep to her defense, alleging that those accounts did not belong to her. Well, it was subsequently discovered, no, they did in fact belong to her. Not only that, a lot more was found that belonged to her. So there's not a lot known about Dr. Manakawala, and we'll be getting into that. But so the state is arguing that in this motion, the motion for admissibility, that that these statements fall under an exception to confidentiality, okay, which is privileged communication between psychologists and clients. Uh, uh, Now they're trying to uh, say that because it's a homicide trial, that these there's exception to confidentiality. However, a psychologist licensed under the Indiana Code may not disclose any information. So there's some contention there, but the state is arguing that that under this Indiana Code, that trials for homicide uh, don't count. Okay, don't count. All right. So number three, the defense's motion to suppress second statement um, is about the investigation of Holman. And the defense is arguing that Allen's rights were violated, okay, during his custodial interrogation because there was no Miranda, there was coercion and intimidation by law enforcement. There's a missing video footage, just like there is for tons of stuff in this case, which is it smells of corruption. And there's a Jerry Holman appeared to be intimidating Mr. Allen during this, pushing the limits of interrogation tactics with no Miranda warning, and statements were made under duress. So we'll get to that. Then there's your state's objection to defendant's motion to suppress. Okay, in this, it's alleging that the statements were made voluntarily and not through coercion, totally ignoring the fact that the Odinist guards were there coercing him, and totally ignoring the fact that he was questioning his attorneys whether his wife was alive, his wife was okay, and his family was alive, and his family was okay, which would lead one to believe that his family and his wife's lives may have been threatened, and he may have been coerced. Um, However, the state is alleging that these statements were made voluntarily, not through coercion, and that the statements were made to staff and inmates and not via an interrogation. Well, we understand that, but again, the medication combined with the intimidation, combined with the threats to his wife's and family's lives, may have caused him some sort of impetus to confess. Not only that, we find it very odd that there are many elements of the confessions that do not match up with what is known about this crime. So you have to ask yourself about the validity of any of that. But the state is objecting to suppressing that, and claims that the psychological and physical coercion are unfounded and want specific examples. Okay, so that will be looked at, and let me stop here and just say that we know that this judge has exhibited bias and preference to the prosecutor. Okay, so we know that the judge has historically been extremely preferential to the prosecution in this case, almost to the extent of malfeasance. Just recall some basic examples, like the fact that she tried to remove them for the crimes of another individual, Mr. Mitchell Westerman. She also remember the fact that when she had her preferred defense attorneys on there, which were Scrimmon and Libredo, she offered them an opportunity for a Franks hearing. Well, we've had 4 requests or filings for Franks notices or hearings, and we've had 0 Franks hearing. So although she offered Scrimmon and Libredo the opportunity for Franks hearing, she absolutely refuses to give Baldwin and Rozzi the opportunity for Frank's hearing. And I just want to ask you this one question. If the party in the case is Richard Allen and not his attorneys, why does it matter who gets the Franks hearing? Okay, because wouldn't uh, the pertinent party be Mr. Allen? So isn't it Mr. Allen who gets a Franks or doesn't get a Franks? Why would it matter who his attorneys are at any particular time? And why would Scrimmon and Libredo get the Franks opportunity, but why, when Baldwin and Rozzi are reinstated, would they not be offered that? And why would they still be begging for it? Okay. All right. Moving on. There's also the defendant's motion to compel a motion for sanctions. Okay, which is basically alleging additional discovery violations, the withholding of exculpatory evidence, the failure to give up all discovery that's pertinent until the absolute last minute, or until they become aware that the defense is aware of particular discovery that has not been handed over. Also alleging that there was a voluminous, disorganized release of discovery, which I think is a little less pertinent. But remember, there's also all the missing discovery. Where are our 70 days of investigation? Where's the first full week of recordings? And where are the family's cell phone data dumps? And all of the extremely questionable missing discovery that the state is alleging they have no control over. Okay, something that would not be accepted in any case. We have here, and the defense is saying, "What the hell?" Okay, the discovery. There was a period that went beyond. We just covered that recently with this request to remove the judge that was sent to the Supreme Court and denied because of technicalities. However, it's still the case that she's gone 2, 3, 4, 5 months and more. She's gone extremely far beyond the 30-day limit to rule and on these Franks hearings. And we know we got 4. She's pretending they don't exist. Okay, and it's a cloud. It's a storm cloud that's building above this case that we know at this moment that this whole thing is being set up for appeal. I mean, it's very clear now that that this whole thing is being set up for appeal. So I think that we're going to have quite a shitstorm on our hand, to be honest with you. Okay, there's also the Liberty Germans delayed and questionable phone data release. There's the late submission of the Click report, the Todd Click report. There's chain of custody questions. There's there are missing documents that they are requesting that be compelled. They want explanation from the prosecution about these false statements and delays. There's a request for sanctions, like jury instructions. They want no objection to belatedly produced evidence, and prohibiting of the use of late disclosed or extracted phone data. There's just a whole bunch of stuff that we will read through it. Okay, then there's the defendant's motion to vacate the safekeeping order, which is that that Sheriff Liggett says there's no issue housing Allen in the county jail. There's transportation issues. There's lack of evidence that Allen is in danger. Uh, they want him housed in Cass or Tippecanoe County Jail. A whole bunch of stuff with that. I don't necessarily agree with it. I have to be honest with you. I don't. I mean, who knows at this point if that's a good move or not? I mean, I think I'm actually astonished that he hasn't been Epsteined. Um, is my opinion. So I don't know if that's necessarily a good thing. Sometimes you let sleeping dogs lie and you let things be, but there is that. Then there's the state motion in limine, in which the state requested the defense be prevented from mentioning uh, tons of stuff you would not believe about this motion in limine. And honestly, I think this is one of the most important ones that's being looked at in these next 3 days, and it's astonishing. It's astonishing, but the state's requesting that there's no mention whatsoever in this trial about the state's counsel and their actions, the defense opinions on the witnesses, and Odinism, Click, Keegan Klein, just tons of stuff you would not believe. That the prior crimes and criminal records of witnesses, the geofencing at all, uh, the total disorganization and all the problems with the discovery, and not only that, anything at all mentioned in the Franks memorandum. So the state is asking for broad limitation of pertinent facts be brought into this, and it's unbelievable in my opinion. And the state is alleging that all of this is confusing and irrelevant, but it's not. It is definitely not. And the fact that that would be granted, which is very possible because of the absolute obvious bias and preferential treatment from this judge, it's actually frightening. It's actually frightening because all that is requested to be limited are things that probably should be brought out in the defense of Richard Allen. And if you watched at all the Karen Reed defense at work, imagine if all of that defense uh, product that Karen Reed's attorneys presented would have been limited. Karen Reed would be under the jail right now. She would, because that was the case. Just like for the most part, that is the case for the defense of Richard Allen. Okay, and of course there's the defense's response to the limitation motion that we're just discussing, and it says that it's all bullshit, and it actually is. So it's a good response to the state's motion in limine. So, but all of that's being decided, and it's like I said, to me that's the nexus for this whole case. Okay, so it's extremely important. It's going to be interesting to see how the attorneys and the judge try to downplay its importance. Then you have the second motion to dismiss by the defense counsel, requesting the defense dismissal of murder charges against Allen due to the missing, destroyed exculpatory evidence. In other words, you dismiss this shit because you've lost 70 days of stuff. You've lost the first full week. You've lost the family's cell phone extraction, all of this, that, and the other. It's very important to preserve evidence on third-party guilt. It's exculpatory evidence and discovery that even you don't think is important. It's important to preserve all of that. None of that was preserved. It may have even been intentionally destroyed, which is a whole other ball of wax, a can of worms. Trust me, if it's discovered that all of that was criminally, intentionally destroyed, then you have a whole other federal case on your hands. But we'll get to that later. There's a lot of preparation and things that the defense has to consider that they are entitled to. It's not up to the prosecution to build the defense's case for them. It's up to the prosecution to be transparent, to be actual honorable members of law enforcement or extension of the arm of law enforcement, and to present what is there, which will show no motive to railroad, bury, implicate, cover, or anything of the sort, any individual and any individuals, and to allow the defendant to formulate his own defense, whether by himself or through defense counsel. And and the way that things appear to have been done appear to demonstrate some railroading tactics, some possible conspiracy to hide exculpatory third party and family related inculpatory evidence, those sorts of things. It's really bad. It's really bad. And I would not be surprised if we have a federal investigation into this, just like we did with the Karen Reed trial. Okay, now there's also the motion to dismiss. The second motion to dismiss, and this is oh, that's what we're talking about. It's the murder charges being dismissed because of all of this skullduggery, but also that the interviews and the phone data of Holder was and others was intentionally destroyed. Okay, law enforcement did not provide the complete records of all of that stuff. It was intentionally destroyed, possibly. It's criminal acts. Okay, criminal acts. In bad faith, constitutional violations, professional misconduct, crimes of the highest degree, um, and these issues allegedly would uh, prevent any sort of anything like a fair trial. So they are requesting dismissal of charges, which, based on this judge's obvious bias, would never happen. Okay. All right. So then there's the state's response to the defendant's second motion to dismiss, in which they argue that that yeah, all of that stuff is not material, exculpatory, or useful, and it's not destroyed in bad faith. It's just an accident, and it wasn't important anyway. You really believe that? Do you really believe that all of that was accidental, and none of it was potentially important? I mean, let's be real here. They're denying that law enforcement purposely destroyed Holder's phone data and the interview recording, and denies concealing evidence, and that none of them were done in bad faith, which all seems like it's complete BS, because it appears that all of this was done in bad faith. And yes, so like I said, setting up for appeal very nicely, if I must say so myself. Now, let us get on to reviewing some of these. We will review all of them, possibly not today. Maybe we'll take a couple today, a couple tomorrow, a couple the next day, and then we'll summarize with all of the findings once it's all done. But I want you to know exactly what we're looking at with these, because although I just summarized them all, and I think all of you have a good understanding of that, I think it'd be really important for us to look closely at each one again, because we've looked at them in the past. But let's look again at each one and really understand what we're doing. You know, what are we looking at, and what's being decided? Because, like I said, all of these people covering this case, they're going to give you all kind of different angles. You're going to get people who just want to be up to the minute with the latest. You're going to get people who want to show you photography. You're going to get people who have some agenda with the narrative they're trying to push, and shilling for the prosecution, shilling for the defense, whatever. I'm not going to be producing that. What I want to do is I want you to understand, and anyone who watches this, I want you to understand what actually is being decided. You know, not what the opinions are about it, or not what the outcomes are of the decisions, but we will cover that, obviously. But let us understand what is being decided. Okay. Okay. So just a moment. Okay. Firstly, let's look at this one. Motion to suppress statements. Okay. This one is being decided, right? Um, Defendant Richard Allen, by counsel, respectfully requests that this court suppress as evidence in this case any and all written and oral communications, confessions, statements, or admissions alleged to have been made by Defendant Allen during his pre-trial detention in this case. In support of this motion, Defendant Allen states the following. Defendant Allen is charged with 2 counts of felony murder and 2 counts of murder. During the course of Defendant Allen's pretrial detention, it is alleged that Defendant Allen communicated incriminating statements to state actors and or their agents, all of which the state of Indiana intends to present to a jury at the trial in this cause. The statements were involuntary and thus obtained in violation of the following: Fifth Amendment, Sixth Amendment, 14th Amendment, and Articles 1, Sections 12, 13, and 14 of the Indiana Constitution. Okay, so let's stop there. So you guys realize this is a constitutional argument here. Okay, this is a constitutional argument stating that these statements acquired during his detainment are constitutional violations of the 5th, 6th, 14th Amendment and the state constitution of Indiana, sections 12, 13, and 14 of Article 1. Okay. The statements sought to be suppressed were obtained as a result of psychological and mental coercion. Okay, psychological and mental coercion illegally directed against the defendant, and such statements were then involuntarily given. Okay, so this is alleging that he was coerced, psychological torture, and mental torture, okay, that coerced these statements, and therefore they are constitutionally invalid because they were involuntarily given. Okay. The statements sought to be suppressed were obtained as a result of physical coercion illegally directed against the defendant, and such statements were therefore involuntarily given. Okay, now that's important. So you understand in the previous paragraph, it asserted psychological and mental coercion. Okay, so those are mind games, right? Psychological intimidation, that's mental. Psychological, mental, and perhaps medical. It's mental, psychological, mental. But here in paragraph 5, the defense is alleging they were physically coerced as well. Now, what evidence do we have of that? What examples? What says that is true? I'm not sure, but there are your allegations that there's psychological, mental, and physical coercion while being detained that resulted in these statements and admissions, and therefore those statements were involuntary, meaning coerced, and therefore it would be constitutionally violative to allow those to be given to a jury. So it says, therefore, any and all communications, confessions, statements, or admissions alleged to have been offered up by Defendant Allen were elicited in violation of his constitutional rights under 5th, 6th, and 14th Amendments to the Constitution of the U.S. and his rights under Article 1, Sections 12, 13, and 14 of the Indiana Constitution. So the constitutional arguments there, and remember, that would also cover any written. So any letters, any phone calls, any statements to correctional officers, to Olderness guards, anyone else, okay? Okay, so Defendant Allen here at the end requests the court conduct a pretrial hearing to determine if the statements alleged to have been given were voluntary in nature. That's what's going on now, okay? Suppress as evidence, sorry about that, in this cause, any and all communications, confessions, statements, or written or oral, blah, blah, blah. Okay, so you see what's going on. You see what's going on. That's being decided now, extremely important, because remember that for the longest, when these people who run around pretending to know anything about this crime, like whether it's guilt or innocence on the part of Mr. Allen. Okay, those people who want to run around calling him a baby killer, not knowing about his level of involvement in this crime, and the people who say the judge has never done anything exhibiting bias, the prosecution and law enforcement has not done anything to indicate any sort of uh, corruption or malfeasance on their part, despite the extreme amount of missing investigation and discovery. Despite all of that, those who would try to convey that the prosecution is perfect, law enforcement is perfect, the judge has acted perfectly, everything is fine, and Richard Allen is a baby killer. Those folks right there, who obviously have no way of knowing whatsoever anything about the crime unless they were physically there. And I wonder, were they physically there? Were some of them physically there? Is that why they do this? Do they actually know? Is the reason you know that he's a baby killer because he was and you were there? I'd like to know. I'd like to know from you guys who go that far. Okay. However, they would like you to think that that his confessions, which they called them confessions, were important. Okay, they say these confessions, he confessed. The only two things they've ever had to run with is he was there and there's a bullet from his gun and he confessed. Okay, sure, okay, sure. That's your argument. That's your argument. That means he's a baby killer. I mean, because if that's the litmus, if that's the bar that has to be met, I mean, anyone could be accused of any crime and immediately be guilty. Okay. So I could call anyone in my chat an old lady killer because they knew someone or knew of someone uh, who was an old lady who died. So I could say, oh, well, oh, you must be an old lady killer because you knew them. And if they made a joke of some sort in sarcasm and somehow self-implicated in a sarcastic manner, which would clearly not be true, but a bit of sarcastic humor, I could also look at it and say, "Hey, well, you confessed." So these extreme leaps of logic and and what do we call it? Rigor or diligence. Okay, these extreme leaps of logic and due diligence. This is what they do. This is in fact what they do, and it's amazing. It's horrible. Okay, so let's see if we can pull up another one. We don't do those extreme leaps of logic and lack of due diligence. I mean, what value is that? Because this guy sitting here in front of you has no clue whether or not Richard Allen is guilty or innocent in any way whatsoever in this crime. Because how could I? I was not there. Um, so I won't pretend to know what happened regarding Mr. Richard Allen's innocence or guilt. But we can look at what we can critique and we can discuss is what we know. Okay. So what we know is like what we've seen transpire since his arrest. All right, so let's look at this. Let's see. This is called Memorandum of Law in support of defendant Allen's motion to suppress. And I don't know if I'm going in the right order here. I might be messing up. Oh my gosh, I think I'm messing up. Hold up. I think I want the state's answer. So just a moment. And it's too many to pull up here. So let's see. State's answer. There we go. Okay, here we go. State's objection to defendant's motion to suppress, filed April 11th, 2024. Okay. So now comes the state of Indiana by Nick McClellan. And respectfully objects to the defendant's motion to suppress, would ask the court to deny the same. In support of said motion, the state would ask the court to consider the following. The state has provided the defense with statements of Richard Allen. Okay, I know. Let's go one by one. Let's go one by one here. True. State has provided the defense with statements of Richard Allen. Okay, I would say that's true. Those statements include phone calls made by Richard Allen to his wife and his mother. True. Statements he's made to Indiana DOC staff and inmates. True. The statements made to Indiana DOC staff and inmates, referred to as suicide companions, consist of statements on door sheets. These door sheets are forms provided by the Indiana DOC for monitoring behaviors and statements of Allen at a frequency determined necessary by mental health personnel. The state has identified and provided the names of all suicide companions, which the state intends to call as witnesses for confessions and relevant statements against his own interest. Which includes 16 correctional officers, 8 inmate companions, the warden, sorry for the text message, mental health personnel, and Indiana State Police officers. So gosh, have mercy. That's a large number of people. So you got 16 plus 8 plus another undisclosed amount. Lots and lots of individuals, okay? The admissibility of a confession is controlled by determining from the totality of the circumstances whether the confessions were made voluntarily and whether the confession was made voluntarily and was not induced by violence, threats, or other improper influences that overcame the defendant's free will. Yes, no shit. Okay, the same test determines whether Miranda rights were voluntarily waived. Thus, the voluntariness of a defendant's waiver of rights is judged by the totality of the circumstances. I would agree. Okay. An express, written, or oral waiver of rights is not necessary to establish a waiver of Miranda rights. Okay. The Fifth Amendment's privilege against self-incrimination applies to the states through the 14th Amendment. When a defendant challenges the voluntariness of a statement under the U.S. Constitution, the state must prove by a preponderance of evidence that the statement was voluntarily given. You get that, right? You get that. The state must prove by a preponderance of evidence that the statement was voluntarily given. So that's important. In addition, the Indiana Constitution provides that no person in any criminal prosecution shall be compelled to testify against himself. The Indiana Constitution requires the state to prove beyond a reasonable doubt that the defendant voluntarily waived his rights and that he voluntarily gave his statement. So see, that's an extreme burden we're looking at. And even McClellan is acknowledging that. So there must be a preponderance of evidence that the statements were voluntary, and the state must prove beyond a reasonable doubt that the defendant voluntarily waived his rights. Okay, so I think that onus is on the state to prove that beyond a reasonable doubt with a preponderance of evidence. It's a lot. The self-incrimination clause of the Fifth Amendment protects an accused only from being compelled to testify against himself or otherwise provide the state with evidence of a testimonial or communicative nature. In order to be testimonial, an accused communication must itself explicitly or implicitly relate a factual assertion or disclosure. Sorry. Okay. Just a moment. Okay, I apologize. False alarm from the dog. Now, absent interrogation, there is no infringement of the Fifth Amendment rights identified in Miranda and no occasion to determine whether there has been a valid waiver. The term interrogation under Miranda is not only to express questioning, but also to any words or actions on the part of the police other than those normally attendant to arrest and custody. That the police should know are reasonably likely to elicit an incriminating response from the suspect. Since police cannot be held accountable for the unforeseen results of their words and actions, the definition of interrogation can extend only to words or actions on the part of police officers that they should have known were reasonably likely to elicit an incriminating response. Okay. That the defendant is being held in pretrial detention for his safety pursuant to court order, inmates of the PLUS program and subsequently corrections officers at the IDOC holding facilities been assigned to observe Richard Allen and record his behaviors. Yes, that's clear. That's clear. Which has included documenting statements made by Richard Allen. Yeah, you think? Now see, there I think that's no mistake, okay? So what they were doing was surveilling Richard Allen, okay, for this explicit purpose. That the assignment of correctional officers to replace inmate companions coincided with Richard Allen being provided with legal documents for his case. Therefore, it was determined no longer appropriate for his inmates to provide companion services due to gag order and protective order. Okay, I get that. I hope everyone gets that. That the defendant alleges all his statements subsequent to arrest should be suppressed for the reason that they are all involuntary due to the conditions of his pretrial detention, which they characterize as illegal coercion, either psychological or physical, in violation of constitutional rights. Not true. Okay, they are not alleging that due to his condition of pretrial detainment that they were illegally coerced psychologically and physically. That's not being alleged here. What's being alleged is that in addition to his pretrial detainment, there was psychological, mental, and physical coercion, which means individuals, in addition to his physical containment and detention, individuals psychologically coercing him, mentally coercing him, and physically coercing him. Remember, we had the statements: is my wife alive? Is my wife okay? Is my family alive? Is my family okay? So not only that, but you have individuals that you now assigned to sit at his door and take notes and surveil him, okay? Statements made by Richard Allen, which the defense seeks to suppress, are unsolicited and voluntary. You don't say. How can you prove that? If the burden is on the state to prove this beyond a reasonable doubt, how do you prove beyond a reasonable doubt with preponderance of evidence that the statements were unsolicited? How do you prove that they were voluntary? Do you have recorded the entire 24/7 that he's been detained? Do you have that recorded, Nick McClellan? The defense has alleged physical coercion by state actors that has resulted in involuntary statements by Richard Allen that should be suppressed. The defense has also alleged that psychological coercion by state actors has resulted in voluntary statements that should be suppressed. True, true, and true. That the defendant has not alleged that any of those statements are the result of interrogation by law enforcement while in custody, and the state would assert that Richard Allen is not being interrogated by law enforcement or any agent of the state during his pretrial detention regarding the charges pending herein or regarding any other criminal activity. That case law and application of the protections of Fifth Amendment indicates that absent interrogation by law enforcement and or an agent of the state, the defense does not have a basis to challenge the admissibility of voluntary statements made by Richard Allen. Yes, but what if those DOC officers and those other inmates were acting on behalf of the state? If they were acting on behalf of the state, isn't that acting as an agent of the state? Where does that interpretation come in? The state acknowledges its burden to show beyond a reasonable doubt that the statement was not obtained in violation of the Indiana Constitution or by a preponderance of evidence that the statement was not obtained in violation of the U.S. Constitution. Oh, I'm sorry, I skipped ahead. However, the state does not believe the constitutional protections allow for the defendant to allege that all statements during his pretrial detention are the result of coercion directed against him. That's weak. Okay, now, in my opinion, that's a very weak argument there. Let's read that again because that one is important. That's number 13. Okay, there you go. At the bottom, the state acknowledges its burden to show beyond a reasonable doubt that the statement was not obtained in violation of the Indiana Constitution or by a preponderance of evidence that the statement was not obtained in violation of the U.S. Constitution. That's a huge burden, and the state is acknowledging that. Here we get to here's the kicker. However, the state does not believe the constitutional protections allow for the defendant to allege that all statements during his pretrial detention are the result of coercion directed against him. Yes, he does. If the statements were the result of coercion directed against him, he is allowed to allege that. And it is the burden of the state to prove otherwise. This posture requires to begin with an assumption that his pretrial detention in IDOC by its very nature is coercive interrogation by a state actor. No, he's conflating the argument there. No, what the judge has to consider, the court has to consider, were the persons monitoring Allen acting on behalf of the state as part of his pretrial detention in obtaining these statements? Were those coercing him, threatening his family, psychologically and mentally coercing him, torturing him, were those actors working on behalf of the state to elicit those confessions and incriminating statements? The defendant is making a blanket argument that all statements by Richard Allen are the result of improper influences based on the defendant's mental state without having to address each statement and its unique circumstances. The defense argument ignores the case law regarding application of their cited constitutional protections by skipping over the threshold of showing or alleging interrogation by law enforcement or their agents. The defense motion expects the court to accept that all inmates, employees, and third-party medical or mental health personnel are acting as agents of the state, specifically law enforcement, with the purpose of illegally coercing statements from Richard Allen for his prosecution. Yes, but were they? Were the Odinist guards who were threatening to kill his wife and threatening to kill his family and possibly him, were they acting on behalf of the state? Now you tell me, what would any reasonable person believe? Now here comes the gaslight from Slick Nick McClellan, Master Mason. The allegations and assumptions are absurd, unfounded, and not supported by the motion filed or any facts of evidence. Well, that I would agree. I would agree. I haven't seen evidence. That's maybe that has to be supplementally filed. Where's the evidence? That's what I questioned earlier. Where's the evidence of this? Motion to suppress all of Richard Allen's statements is another attempt by the defense to derail this case with conspiracy theories. Okay, there you go. You're giving yourself away because we know how the New World Order and the wacko communists, we know how they do things. You call things conspiracy theories to immediately discount their validity because you know by putting a blanket terminology over certain things that people will naturally have a bad taste in their mouth. So just like I said earlier, things don't have to be true in PR. When you just say something, it puts it out there, it makes it true in people's minds. Okay? That's the problem with misinformation and disinformation and slander. Because when you just say something, doesn't matter if it's true or not, just the saying alone, some people will automatically take it as true. And so here he's saying conspiracy theories to inflame the public to believe the government has unjustly pursued charges against Richard Allen. No, we don't think you've unjustly pursued charges. We think you've unjustly deleted exculpatory evidence. You've deleted investigative product. You've deleted uh, forensic data. You've railroaded Richard Allen. You've tried at every turn to remove his counsel of choice, and you've instigated individuals uh, in the public sphere to attack those who counter your theory. Okay? So you've put people in motion, you've set things in motion so that people on this internet would be attacked, doxxed, possibly killed in order to shut them up and silence them because you don't want a counter narrative out there. You only want the state's narrative out there in the attempt to railroad Richard Allen, whether he's involved in this crime or not. The state requests that the defense be required to identify the specific statements of Richard Allen that were illegally coerced and identify the state actor whose conduct supports the allegations of coercion and describe the conduct they believe to either be physically or psychologically coercive before the state is required to respond for further analysis by the court. I would agree with that. There's nothing wrong with that. Okay. Show the statement. Who took the statement? What evidence is there that that person was mentally, psychologically, or physically coercing Allen? Yes, sure. Let's go ahead. Let's see it. Let's put it out there. Let's shed some sunlight on that. Okay? Let's use sunlight as that greatest disinfectant, and let's see those statements, and let's see who took the statements, and let's see their behavior. What have they done to Richard Allen prior to receiving those statements? Let's hear from Richard Allen. Did anyone threaten to kill your wife? Who? Who did? Did anyone threaten to kill you? Who did? Did anyone threaten to kill your family? Who did? Let's hear it. Let's see that evidence. Let's shed some sunlight on this case. In the absence of specific allegations by the defendant as to each statement against his interest that is involuntary and as a result of law enforcement interrogation, the state asserts that the defendant has not sufficiently identified statements subject to a motion to suppress. Okay, no problem with that. Okay, so although there was the extreme gaslight in paragraph 15, in paragraph 16 it gets back to basics, which is where's the evidence? Let's see. Let's specifically lay out each piece of this, okay? Because just like a puzzle, the only way things are put together is when you take each piece, you can clearly see it, you see how the shapes fit, you see the colors, the patterns, and you put that piece with the other, and because of the light and the identification of all aspects at 360 degrees of that puzzle piece, you're able to put those pieces together and understand the larger picture of what you're looking at. And that's what we want to see, and that's what the jury should want to see, that's what the judge should want to see, that's what the defense attorneys should want to see, and that's what the prosecution should want to see. All right. again. So this was your state's objection to defendant's motion to suppress April 11th. Okay, filed April 11th. And actually, let's look at that again. No, I am wrong there. The motion to suppress was April 11th. This was filed April 23rd. Okay, that's what we're talking about. April 23rd. I figured something was wrong with that. Okay. So that's filed April 23rd. I don't know why these dates aren't lining up for me. But we'll just leave it be. Okay. Um, now let me continue on. Maybe we'll do one more if I can get it up before we leave here. Just a moment. Apologize how long it's taking. I didn't have that one up. Haven't had this one up. All right, let's see. There we go. Let me take a look at the chat before we go on. Let's see. Oh yeah, chat. Great job. I'll just leave you to go. Keep going. Great job in the chat. Well, what else did I have up here? We can just do this one. Let's see. Is this it here? Let me All right. This is a memorandum of law in support of defendant Allen's motion to suppress. Just a moment. Just a moment. Okay. All right. So we'll do this one. This one is already up in the queue here. So let's go ahead and look at this one because it's related anyway. It's very important. Defendant Allen was arrested in October of 22 and immediately detained in Carroll County Jail. Allen was thereafter transferred to the White County Jail and ultimately charged with 2 counts of felony murder. The charges were lodged against him on October 28, 2022. On November 3rd, 2023, Carroll County Sheriff petitioned the court for an order transferring jurisdiction of Allen's custody from the Carroll County Sheriff to the Indiana DOC. On the same day and without the formality of a hearing on the sheriff's request, Judge Diener signed an order, safekeeping order, transferring Allen's custody to the IDOC without Allen or his representatives having any freaking input into his pretrial detainment. At the time the court signed the safekeeping order, Allen had yet to have appointed counsel. In fact, Allen's court-appointed public defenders, Rossi and Bowen, did not enter their appearances until November 14, 2022, and therefore Allen had no input as to his pretrial detention circumstances. The record should also reflect that the safekeeping order and all other exhibits referenced herein have been personally served on the court in the form of a supplemental appendix. Allen was then shipped off to Westville Correctional Facility and placed in maximum security segregation unit by prison officials termed WCU. The record suggests that just prior to his transfer to WCU, Allen may have made a brief stop at the Reception Diagnostic Center, RDC, where some sort of intake procedure may have taken place, but it does not appear that Allen underwent any formal mental health assessment or testing to establish a baseline in terms of his mental health history or needs. From approximately November 1st, 2022 through December of 2023, Allen remained incarcerated in the WCU. Now that's a year and a month. Allen's attorneys were unaware of any other pretrial detainee that has ever been housed at WCU in the history of the facility, and most certainly not in the 5 or so years preceding his placement. Warden John Gallipo was deposed by the defense on Friday, March 22nd, 2024, where he acknowledged that he had worked in the IDOC for 28 years and was the warden at Westville for approximately 5 years leading up to Allen's placement. Warden Gallipo acknowledged that during his entire tenure, he was unaware of any other circumstance involving the pretrial detention of a man who had not yet been convicted of a crime. Okay, that's after 28 years in the IDOC. Allen's attorneys have conducted depositions, watched video from Allen's cell and other video from within the prison, reviewed prison records regarding Allen's detention, reviewed Allen's medical and psychiatric records, and listened to audio interviews of prison inmates and guards conducted by law enforcement officials. Through this process, Allen's attorneys have learned that Allen has been accused of making incriminating statements, both to inmates and to guards. Nearly all of those statements appear to have occurred between mid-March of 2023 and June of 2023. Let's read that again. Nearly all of those statements appear to have occurred between mid-March 2023 and June of 2023. Yeah, that's over a year ago. During this time frame, there also exist medical and psychiatric records suggesting that Allen was in a state of psychosis. See attached report of Treatment Review Committee TRC hearing. That's interesting. Did you all know that? Did you all know that during that period, mid-March 2023 to June 2023, at the time that all of these incriminating statements were made, that Alan was in a state, or suggested to be, have been in a state of psychosis, according to the report of Treatment Review Committee TRC hearing? Alan's defense team has learned that Alan was not only detained in an isolation cell in WCU, but that prison officials chose to post inmates at Alan's cell door and required the inmates to keep logs of all of Alan's actions, statements, and behaviors. This appears to have occurred during all hours of day and continued of the course of Alan's stay at WCU. So, in other words, 24/7, he has inmates staged, keeping records during his state of psychosis. These inmates, all of whom are convicted felons, naturally, they are in prison, were not only actively engaged in surveilling Alan's activities, but were also communicating with him from time to time. So this wasn't just observation, this was interaction. Alan's attorneys have also learned that at some point in early of April 2023, prison officials deliberately pulled the inmates from Alan's cell door and replaced them with prison guards, odinous prison guards. Alan's attorneys have learned that this appears to have been prompted by an inmate or inmates engaging Alan regarding his pending charges and communicating Alan's thoughts and words to families of these inmates, thereby violating any sense of confidentiality that might exist within the walls of the penitentiary. So you get it? These inmates were engaging Alan about his charges. What does that mean? Let's put it in real terms, because this legal jargon does not necessarily flavor it properly. Engaging Alan, communicating with Alan, means back and forth talking, or at a minimum, one-way talking. This means not only that Alan is sending communications towards them, it means that these prisoners who are monitoring or sitting at his door are sending out words towards his direction. Regarding his pending charges, in other words, baby killer, you murdered Abby Libby, that type of direction. So I would say that they are harassing. Let's put it in street terms. These prisoners, these felons, are sitting there harassing Alan about his charges of murdering Abby and Libby. They're communicating these conversations to their family and friends, also documenting and giving to prison officials. Does that seem a little inflammatory, perhaps? Does that seem a little improper? Doesn't that seem a little inappropriate, to say the least? So he's in prison as a pretrial detainee. He's in prison. His only contact being with other prisoners who are convicted of crimes, who are communicating with him about his murder charges, and then taking that communication, relaying it to law enforcement and prison state actors, as well as their family and friends. Does that seem a little shady to you? Most notably, Alan's living circumstances within the prison appear to have been designed to expose him to some of the harshest conditions that even the most heinous of convicted offenders have not endured. Yes, in other words, he's in a max security prison in solitary confinement, being babysat by others who should be, because they are convicted criminals, who are sending communications his way about his murder charges, of which he is still technically innocent because he is a pretrial detainee and not convicted. And they are then handing that communication to state actors and their friends and family. This coercive environment was initially the product of Allen being detained in an observation cell used for convicted inmates with suicidal ideations. This single cell, located in a pod, is one of the approximately 60 individual segregation cells, all containing felons convicted of crimes such as burglary, robbery, and child molestation and murder. So, burglary, robbery, child molestation, and murderers. These are who are babysitting him. And he's being accused of child murder. Each and every one of these inmates has the ability to communicate with Allen. Wow. Boom. Each and every one of those inmates has the ability to communicate with Allen by yelling at him at all hours of the day and night, and by chastising him every time he was removed from his cell for purposes of recreation, showering, or other administrative reasons. Yeah, remember the letter that we received in which it was stated that they were screaming at him, calling him a baby killer, a child murderer, day and night, 24/7, and that they were going to kill him? Remember that? But all of the prosecution shills and the page agent provocateurs on YouTube wanted to say and allege that, oh, well, the statements from that individual are invalid because he's a prisoner. Yeah, no shit, he's a prisoner. Everyone's a prisoner in there except for Allen. Allen's attorneys have learned that he was referred to as a baby killer. See what I said? And that he was a target of other similar accusations during his stay in the WCU. Who else calls him a baby killer? Let me think. Tommy Frost, Mark Robert, all the other, Sleuth Intuition, all your other prosecution shill YouTubers. Prison records reflect that Allen was placed on suicide watch during the majority of his stay at WCU, including upon his initial detention in November of 2022. See attached mental health order of 11/3/2022. This occurred despite the fact that there were no underlying findings to suggest that he was suicidal. Allen's designation as suicidal subjected him to even harsher circumstances than those of other offenders on the unit. For example, Allen's bed consisted of a metal plate with a thin mattress, all of which was just a few inches from the concrete floor. Allen was issued an anti-suicide smock, which covered his body no better than that of a garment of a caveman. Or I would say even worse, because caveman had animal skins, which were warm and thick. Allen had basically a paper thin garment. So he's cold. He's in a concrete floor with a paper thin mattress. Allen's food was served to him through a cuff portal during his dining, and his dining habits involved him sitting on his bed or on the floor, as his cell was not equipped with a table or a chair that would otherwise serve even as a rudimentary dining arrangement. Allen's cell also contained a steel toilet and sink, both in direct line of sight of the inmates and guards assigned to surveil him. The toilet bowl was located approximately 24 inches from his bed. Allen's attorneys learned that Allen was not only under constant surveillance, but that the lights remained on his cell for many days and nights. Yeah, imagine that. 24/7 lighting. Don't you know that's how do you induce distress in laboratory animals when you are trying to distress them for the purposes of testing stress levels? Well, you put them in a very uncomfortable environment, such as the one just described, and you leave the lights on 24/7 because it disrupts the sleep cycle and the melatonin and the various hormones in the brain. That's how you do it. It is also true that due to his suicide watch designation, he was afforded less or no recreation time and less of an opportunity for showers. See the attached audio of Timothy Weiss, corrections officer, at the 3 to 4 minute mark. So he gets less exercise, less sunshine, less sanitary regimen. So he's dirty, he's malnourished, he's uncomfortable, his brain hormones are being fucked with by the lighting, and he's not sanitary. In essence, his suicide designation was the cause for the removal of additional privileges to the extent the word privilege can even be applied, which in turn further fostered an environment that led to the deterioration of his physical and mental health. Allen's intake records with the DOC reflect that he was 5'5" and 175 pounds at admission in November of 2022. His weight by April of 2023, which is the time period being discussed, was below 135 pounds. So listen, he drops from 175 to 135. That's 40 pounds. He drops 40 pounds into this environment during this time of being tortured. Okay, as a pretrial detainee. Remember, this could be your mother. This could be your mother. This could be your aging mother. This could be your 79-year-old mother. This could be your 85-year-old father. This could be your 18-year-old son or daughter or niece or nephew. Do you understand where we're getting here about constitutionality and the treatment of pretrial detainees? This could be any of your loved ones. In all, for nearly 13 months at Westville, Allen was deprived of any social interactions. Could be your mother. Very little to no privacy. Could be your grandmother. Limited recreation time. Could be your father. Distressing lighting conditions, intimidations by other felons who are convicted of crimes such as murder, burglary, child molestation, etc., intimidating your 18-year-old son or daughter, and deprived of showers, deprived of sunlight, and proper comfort. Could be any of your family members at the drop of a hat. You never know when it could be you or anyone you love. Unfortunately, Allen's unusual detention circumstances would extend beyond the door of his isolation cell. Whenever he was removed from confines of his concrete box, he was shackled with ankle cuffs, a belly chain, box cuffs on his hands, and guided around by guards with a lead, or what most people would refer to as a leash. And this is according to the warden. Not only that, we know about the shock vest that he's regularly outfitted with, and what is alleged to have been activated several times already. This could be your mother. As if this restriction of his basic freedom of movement was not enough, prison officials assigned a videographer to Allen to record his movements around the prison, including when he would meet with his lawyers. Yeah, wouldn't we love to see all of that? Is that in Discovery? Is that in Discovery? Are we going to be able to see all the videography of his extended stay and everything that exists? During his meetings between Allen and his attorneys, he remained shackled, making simple tasks difficult, such as taking a drink of water from a water bottle. He would not be able to communicate as much as a hand gesture due to his shackled state. During other meetings, prison officials placed a video camera outside of a window in the visitation room, required Allen to sit on a hard plastic chair directly in line with the video camera, which was less than 10 feet away, so that they could film his lip motions. Yes. Whatever happened to client-attorney privilege and confidentiality? Remember, pretrial detainee. He's not Hannibal Lecter. He's not convicted of killing children or anyone for that matter. Allen's highly unusual detention circumstance extended even to visits with his wife, During one visit, Allen was transported outside of WCU to a building reserved for visitation for inmates with those in the general population. Allen again was shackled and confined during the transport and ultimately re-robed into a green jumpsuit before seeing his wife. He was, however, unshackled during the visit. His embrace with his wife was controlled by prison protocol, which permitted only a few brief seconds of contact, despite the fact that Allen had not seen his wife for the better part of 6 months. Allen was required to sit on the opposite side of the table from his wife and had 2 prison guards stationed within earshot of each end of the table. They were left absolutely no privacy. Therefore, he could not privately communicate with his wife. The room was completely empty except for the lawyers and a few other prison guards who were also stationed within the building. This provided no background noise whatsoever, which might offer up some aspect of privacy as him and his wife, tried to communicate. And his restrictions did not end here. Allen and his wife were also denied the simple concession of getting a drink of water during his visit, despite the fact that there were a number of vending machines and a water fountain within 10 to 20 feet from the table. Allen's unusual detention involves an even stranger set of circumstances. During the course of representation of Allen, his attorneys discovered that the existence of a dozen or dozens and dozens of police reports, audio interviews, and other investigative findings that centered on a group of suspects associated with pagan Norse spiritual religious practices. These suspects considered themselves Odinists. Okay, we've referred to them as Odinists, although we cannot necessarily say that at all times, absolutely every single one of them specifically refer to themselves as Odinists, because there may be a mixture of the types who would align with pagan Norse spiritual practices, especially considering the fact that within the prison system, the white supremacy specifically is not supposed to be allowed. So they end up congregating under broad umbrella terms such as Odinist. All of which was referred to in Frank's motion and memorandum, and second, third, and fourth Frank's motions and memorandum previously filed with the court. Allen incorporates all of this herein. The details referenced in the Frank's filings, rather than restating the lengthy details in this memorandum. Allen's lawyers also discovered that at least 2 of the guards assigned to his pod and or his movements around the facility also held themselves out to be affiliated with the pagan Norse god known as Odin. See affidavits of Joshua Robinson and Randy Jones. Those are the 2 guards with the Odinist patches who were assigned Allen. And remember, as soon as Holman got the sniff or the whiff of the fact that attorneys Baldwin and Rossi were onto the thought of any sort of Norse pagan aspects to some of these individuals implicated in this crime as third-party suspects and guards, the guards promptly had those patches removed, and those patches within a week disappeared. Within a week of talking to Holman and mentioning the Norse aspect, those Odinist patches disappeared from those guards' uniforms. Never forget that. The guards proudly displayed their Odinistic beliefs on their own prison uniforms, despite the fact that such a display was in direct violation of their uniform policy, according to the warden. And on at least one occasion, one of those guards tased Allen after he was placed in his secured 8x12 cell because Allen refused to remove his hands from the cuff port door of his cell, a cuff port that is barely large enough through which to slide a meal tray. Allen posed absolutely no risk to anyone at the time he was tased. Allen has also battled depression through most of his adult life. He was medicated over the course of his life and, in fact, had sought out therapeutic resources to treat and manage his depression. See pages 4 to 5 of his independent neuropsychological evaluation dated 3/31/24, which is offered up to the court in appendix form. The IDOC gave very little consideration to Allen's condition at the time of his intake and initial incarceration in the WCU, especially given the unusual circumstances in which he was detained. It is also believed that Allen's medications were administered in a less than consistent fashion. Remember, I said he may have been medically coerced because the medications affect his psychology. He may have been psychologically coerced because of his conditions. He may have been mentally coerced by things he was said and things that were done to him. And he may have been physically coerced by his environment and by his treatment by those who had access to him. It is also believed that Allen's medications were administered in a less than consistent fashion while he was on the unit, all of which would have contributed to his ability or inability to endure his living environment during his pretrial detention at the WCU. Okay. Issue. The issue in this case is whether the state violated Allen's Fifth and Sixth Amendment rights and federal and state due process rights by detaining him in solitary confinement in a maximum security prison segregation unit while he was awaiting trial and having him monitored by other prisoners and Odinist prison guards 24/7 with the lights on while monitoring him, while communicating with him about his charges and taking written and recorded uh, notes of his statements. Allen's statements were involuntary and should be suppressed. Rule: coercive police activity is a necessary predicate to finding that a confession is involuntary within the meaning of the Due Process Clause, Colorado versus Connolly. Apologize for the things. Thank you for the donation and for the Cash App. I'm not going to name you. I'm not sure if you want to be named, but thank you for the Cash App. I appreciate that. And thank you all for sharing, liking, contributing, and all the support to the channel. I appreciate that. However, coercive police activity is not a necessary prerequisite to challenge the voluntariness of a defendant's statement under Article 1, Section 14 of the Indiana Constitution, as there may be other elements that would not or that would tend to support the finding of involuntariness. State versus Banks, okay, 2013. The proper standard under the Indiana Constitution is whether the confession was, quote, freely self-determined and the product of a rational intellect and free will. Hurt versus State, 1998. Thus, courts look to the totality of the circumstances to determine if the confession was voluntary, taking into account many factors, including 1, whether the statement was made under a court order. 2, use of police trickery. 3, threats or promises by police. 4, defendant's race, age, or disability. 5, length of detention. 6, physical coercion. 7, illegal police practices. Well, God damn, I think pretty much there we have it all. You mean you have it all there? Okay, I mean just that quote there about the standard, the proper standard being under Indiana Constitution being that the confession or statements be freely self-determined and the product of a rational intellect and free will. Do you think a rational intellect and free will would be eating his own feces and smearing it all over himself and asking if his wife is dead, if his wife is okay, if his family is dead, is his family alive, is his family okay? Do you think that that would sound like a rational intellect and free will and self-determined? Okay, analysis. Notwithstanding the lower standard for showing involuntariness set by the Indiana Constitution, it is indisputable that Allen's detention circumstances were manufactured by the Carroll County Sheriff purposefully and without the existence of any sense of due process, as the court signed the safekeeping order without requiring the state to establish the burden of proof required by statute. Let's start over. All right. I'm sorry for being so excited, but when this defense or anyone nails a particular statement, I want to reinforce it because it's important. Okay. Remember, Allen had no attorneys at the time that he was ordered for safekeeping. Remember that. Notwithstanding the lower standard for showing involuntariness by the state of Indiana Constitution, remember, which says freely self-determined product of a rational intellect and free will, it is indisputable that Allen's detention circumstances were manufactured by the Carroll County Sheriff purposefully and without the existence of any sense of due process. There you go. It is indisputable. Okay, any of them on the other side wanting us to believe that Allen was placed in Westville in solitary, being guarded 24/7 with the fucking lights on, in a paper thin garment with shock vest, with people discussing the allegations and his charges and all of that fucking punishment. Okay, anyone who thinks that that was not manufactured by the Carroll County Sheriff's Office purposefully with the sole intention of putting him in a distressed environment, you are fucking insane. Because if it was your mother, if it was your son, if it was your son, if it was your brother, if it was anyone important to you or you would understand. Go to prison. Actually, go to your county jail for 24 hours. You'll come out a different person. If you've never been in, you don't even deserve to have the right to speak about it. But this was just the beginning. Allen was then shipped off to Westville and immediately placed on suicide watch in a detention cell where he had little to no accommodations, no privacy. Not even that offered up to the other 2,000 fucking convicted inmates housed in Westville. Okay, almost simultaneous with Allen's isolation from the human contact, prison companions, in other words, actual fucking murderers, rapists, robbers, and all of the above, violent individuals, hardened criminals, prisoners, were placed at his doorstep, tasked with the duty of reporting his every fucking move and his every fucking word. Okay, not only did they do it, they were allowed to communicate with him about his charges and call him a baby killer, call him a child murderer, intimidate him, threaten to kill his family, threaten to kill his wife, and threaten to kill him, most likely. The companions appear to have gone above and beyond the duty by communicating with Allen about his case and even praying with him as he struggled to withstand his rigors of incarceration. Their mere presence at his doorstep is akin to Messiah versus U.S. 1964, where police obtained incriminating statements from a jailhouse informant who engaged the defendant in a conversation and developed a relationship of trust and confidence with the defendant, such that he revealed incriminating information about the charged crime when counsel was not present. The court held that this was improper and suppressed his statements. The trial court should do the same. Okay, let's go back. Messiah versus U.S. 377 U.S. 201, 1964. Police obtained incriminating statements from a jailhouse informant who engaged the defendant and developed a relationship of trust and confidence such that he revealed incriminating information about the charged crime when counsel was not present. The court held that this was improper and suppressed the statements. The trial court should do the same. The trial court's decision regarding admissibility of a confession or incriminating statement is controlled by determining from the totality of circumstances whether the statement was given voluntarily, rather than induced through violence, threats, coercion, or other improper influence so as to overcome the defendant's free will. I mean, let's be real here. Standard indicators for voluntariness include whether the confession was freely self-determined, the product of a rational intellect and free will, without compulsion or inducement of any sort, and whether the accused will was overborne. Well, listen, we've already been informed by his mental health team that he was in a state of psychosis during this time. Okay, we know that he was being threatened by Odinist guards, by possible Odinist prisoners. Because let's be real, if you're white supremacist in the prison. Okay, there's no two ways about it. Okay, you're either black in the black gang, you're either white, you're a white gang, or you're Mexican in the Mexican gangs. You get it? So any of the prisoners who were white would have been aligned with the white supremacist, Odinist, Norse pagan grouping. So you really expect us to believe that these Odinist guards the possible Odinist inmates and the fact that he was undergoing a state of psychosis according to medical professionals at the time, you want us to believe that those confessions were freely self-determined, product of rational intellect and free will, and were not compulsed, or were not the product of compulsion or inducement or coercion or threats? Plus, let's not even mention the fact that these confessions don't match up to the crime. Okay, have you heard of bullet holes in any of the girls? Have you heard of the legitimacy of sexual assault on the girls? Then what is he talking about? In this space, there was not enough room to jog or run. Only an exercise bike. Oh, did I skip? Yeah, I skipped here. It says here, Alan's free will was overcome by the forces of his environment, all of which were placed upon him by the government and its actors. I'm saying again, I'm making a point. In the case that it's the other prisoners or the guards who are doing this and taking this information, are they acting on behalf of the state in this instance or in those instances? Were they acting on behalf of the state? Therefore, can they be considered state actors? Alan, a man with a bona fide pre-existing mental health issue or issues, was detained in an isolation cell, entirely isolated from any sense of meaningful human contact, and then offered up the most basic amenities of life through a cuff hole in his door. He was reduced to sleeping on a mattress that was placed on top of a steel plate just a few inches from the floor. The same mattress and floor doubled as his dining table because the cell had no such accommodations. His attire was reduced to nothing but a suicide smock covering only a portion of his body, and it's paper thin. Alan's healthiest accommodation came in the form of recreation time, not to exceed 4 hours per week. In this space, there was not enough room to jog or run, only an exercise bike and a pull-up bar. Alan's other accommodation would have been a window slit that was inside his cell. His view of anything outside of the boundaries of the penitentiary would have been impaired by the rusty chain link and razor wire of at least 2 separate fences between him and the sense of freedom. To the extent Allen was ever allowed to be removed from his cell, he was shackled at the ankles, wrists, further confined by a belly chain and a cuff port, and guided around the prison on a leash. All ideal ways to confine and control the movements of a convicted killer or some other convict who, in addition to his conviction, posed a viable threat to himself or prison staff. Allen, at 5 feet 5 inches tall, 173 pounds down to 140, soaking wet, or 130 was it? Remember, he lost 40 pounds. With not one single criminal conviction on his rap sheet, meets none of those conditions. Okay? Not only that, when had he ever prior attacked anyone? Why was all of that necessary? Why was the shock vest necessary? Is it necessary sheerly for the purposes of PR to make him look like a Hannibal Lecter, like a mass murderer, like a murderer of children, like a bloodthirsty maniac? Is that why it's necessary to parade him around the way that he is paraded around? Is it PR? Is it mind control? Is it influencing potential future jurors as to his guilt? As if this treatment wasn't enough, Allen was forced to endure the intimacies of his restraint systems even while he was meeting with his court-appointed lawyers inside of the confines of the maximum security segregation unit located inside of Westville Correctional Facility. To add insult to injury, Allen's meetings with his attorneys occurred while he had a video camera aimed at his fucking face, his mouth, to record his lip movements so that someone could go after and transcribe what he had been saying. Recording sessions that should have been afforded the most private of environments so as to protect the relationship between attorney and client. All of this occurred while Allen's medications were being adjusted by a prison medical team, and the combination of which factors reduced him to nothing more than a human experiment. Allen's free will was overcome. Remember, like I said, they want to produce distress in laboratory animals. You put them in a very uncomfortable environment. You distress them with sound and light by leaving a sound at loud volumes and not in a melodious, pleasing fashion. You put on bright fluorescent lights 24/7 a day, mess with the sleep cycle. You scream and yell at him. Allen's free will was overcome. Under the Indiana Constitution, the voluntariness of a statement or a confession must be proved beyond a reasonable fucking doubt. And in reviewing voluntariness, the court looks to the totality of circumstances, reviewing all the evidence in the record, rather than focusing only on the evidence supporting the finding of voluntariness. Pruitt versus State, 2005. Under the U.S. Constitution, the prosecution only has to prove by a preponderance of the evidence that a confession was voluntary. Smith versus State, 1972. As explained below, the state cannot meet its burden of showing voluntariness here, even applying the lower standard of preponderance. I would agree with that. Both standards are not met. The federal courts have a long history of regulating the admission of confessions that have been a product of state action that exploits the weak and compromised through interrogatory and custodial processes. Let's read that again for those in the back who are retarded. Okay, let's do that again. The federal courts have a long history of regulating the admission of confessions that have been a product of state action that exploits the weak and compromised through interrogatory and custodial process. Do you think let's take a test in the chat, and you can just put your hands up, a yes or no, whatever, Y or N. Do you feel that Richard Allen was weakened and compromised through state actions? Let's do the layers. First, by being placed in Westville. Second, by being placed on suicide watch. Third, by being guarded by other prisoners and Odinist guards. Fourthly, by being screamed and yelled at 24/7 by his people in his unit. Sixthly, by being accommodated in a very harsh unit, okay, physically. Thirdly, by being medicated. Fourthly, by being robed in only a suicide smock, which is a paper-thin piece of vestiture. Okay. How about ninthly, by being deprived of sleep and having his circadian rhythm uh, altered and complicated by the use of light uh, stressing techniques, by leaving the lights on 24/7. Not to mention fluorescent lighting, if that is what is indeed used in his cell, is known to distress the brain. That's why it's being phased out in many instances. People who have studied lighting know that fluorescent lighting is horrible for you. The deprivation of sleep function and constant light is more damaging to RA than the duty to watch for possible suicide. It is outweighed in cruel and unusual conditions. Yeah. All right, let's continue. Thanks for the hands up in the chat. I probably lost my face. My face. I've lost my face as well. In Blackburn versus State of Alabama, 1960, the U.S. Supreme Court noted that it had recognized, now pay attention here. Pay attention here. This right here is Supreme Court precedent. That coercion can be mental as well as physical. And that the blood of the accused is not the only hallmark of an unconstitutional inquisition. A number of cases have demonstrated, if demonstration were needed, that the efficiency of the rack and thumbscrew can be matched, given the proper subject, by more sophisticated modes of persuasion. A prolonged interrogation of an accused who is ignorant of his rights and who has been cut off from moral support of friends and relatives is not infrequently an effective technique of terror. I mean, this is our waterboarding argument, okay? It doesn't have to be a knife to his throat to get a confession. Thus, the range of inquiry in this type of case must be broad, and this court has insisted that the judgment in each instance be based upon consideration of the totality of circumstances. Allen's case falls within these federal parameters. In Blackburn, the defendant had a documented history of mental illness, having served in the military, which ultimately resulted in his discharge because of a medical finding that he suffered from some sort of psychosis. And remember that at this time, medical professionals have indicated that Allen was under a state of psychosis. He was in the process of being treated in the days and weeks leading up to the commission of the crime and his ultimate apprehension. After enduring an 8 to 10 hour interrogation, Blackburn was given a prepared written statement with admissions offered up by him in the course of the interrogation, and he ultimately signed the written statement 2 days later. So this is what they did. They stressed his ass out under medication for 8 to 10 hours, and then they went and they picked certain implicatory statements, boom, 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 here, and then said, look, you said this, so fucking sign it. And he signed it. Here, Allen endured a longer, more sustained form of interrogation, one that lasted more than 5 months before he was finally broken. Already suffering from a bona fide mental health disorder, and then having been cut off from the moral support of his wife, mother, and daughter, Allen was weakened to the point where he slipped into a state of psychosis, plagued with grossly disorganized, delusional, paranoid, highly dysfunctional behavior. These behaviors were manifested through verbal confessions that he may have been drugged, verbal confessions to the double homicide, inconsistent with the known facts. Let's back that up. These behaviors were manifested through verbal confessions that he may have been drugged. Verbal confessions to the homicide, however, with inconsistent known facts about the crime scene. Periods of not sleeping for days. Remember what I said about the lighting. Paranoia. Remember about the threats to him and his well-being and his family's well-being. Stripping off of clothes. Yes, what clothes? I mean, you mean the little suicide smock that's thinner than a medical gown? Drinking of toilet water when he's fucking thirsty and he doesn't trust the water he's been being given. Covering himself with and eating his own feces. Yeah, that's odd, isn't it? Isn't that odd? and many other socially unacceptable behaviors. Yeah, but he's totally mentally fit, despite all of that, to confess to killing Abby and Libby because you want him to be. On one occasion, Alan confessed to molesting two young girls and shooting them in the back. See attached transcribed statement of inmate companion Lacey Patton, lines 16 to 17, page 3. On another occasion, he professed his sorrow for molesting Abby, Libby, and others, which he specifically named, to Correctional Officer Michael Roberts' statement between 15 and 16-minute mark. These facts are known to be falsities, none of which are supported by the autopsy findings by Dr. Roland Kaur as to the cause of death of the girls, unsupported by the absence of any evidence that either one of the girls were sexually assaulted near or before the time of their deaths. See attached autopsy reports regarding Abigail Williams and Liberty German. At the time, Allen uttered these falsities. The state actors were in the ready position with pen in hand, documenting the entirety of Allen's mental and physical deterioration with actions stemming therefrom. The infringements on Allen's legal rights did not stop here. Inmate companions then spread the good word of Allen's confessions to inmates in the general population while at Westville, prompting these inmates to then share the information with their respective family members in public. See attached transcripts of Lacey Patton Jr., an inmate, and Jason Elliott, an inmate. Proof of these leaks were offered up to the state in the form of audio recorded interviews and accompanying transcripts, and included in large volumes of discovery dumps received by the defense in the past. However, neither Allen nor his legal team were aware of any self-reporting of said leaks by the state to the defense or by the state to the court, despite the fact that the state was aware of the information as well as, or as early as May 12th, 2023. When Patton and Elliott were interviewed by the law enforcement investigators, Allen's due process rights have been all but ignored. It is also established that the 14th Amendment forbids fundamental unfairness in the use of evidence, whether true or false. Lisbena versus People of State of California. As important as it is that the persons who have committed crimes be convicted, there are considerations that transcend the question of guilt or innocence. Thus, in cases involving involuntary confessions, the court enforces that, or strongly, that the felt attitude of our society that important human values are sacrificed where an agency of the government, in the course of securing a conviction, writings a confession out of an accused against his will, the insistence upon putting the government to task proving the guilt by means otherwise than inquisition was engendered by historical abuses which are quite familiar. See Chambers versus State of Florida and Watts versus State of Indiana. The truth of or falsity of Allen's statements are of no consequence to this analysis. Allen has been treated unlike any other pretrial detainee in Indiana history. Now, why is that? Why is that? The methodology employed by the justice system is one of first impression, and therefore the circumstances created by this methodology should not be a part of any consideration of Allen's guilt or innocence. The system of pretrial detention employed against Allen runs afoul of the Fifth and Sixth Amendments of the U.S. Constitution and Article 1, Section 14 of the Indiana Constitution. It is for these reasons any and all incriminating statements made by Allen while incarcerated should be suppressed. Yeah, once again, let's read that again. Just give me a moment. This is a part I'm very passionate about, so please read this part with me or listen. This is where I side with Allen because, as you know, as far as the crime goes, I have no opinion on Allen's guilt or innocence. I think that it's equally likely he may be guilty. It's equally likely he may be innocent, although it's more than likely, I believe, that he's possibly involved without having direct guilt. Okay. However, this is what I'm passionate about, and this is why I do side with the defense of Mr. Richard Allen. As important as it is that persons who have committed crimes be convicted, there are considerations that transcend the question of guilt or innocence. Okay, so in the bloodthirst to prosecute the guilty, you cannot cross certain lines. That's the bottom line. Okay, that's the bottom line, and that's where the ethics has to come in. And in the course of railroading or police corruption or stacking the deck improperly or coercing confessions, in all of these instances, this is where your ethics have to come in. God has to inform your heart about whether the bloodthirst for whoever killed Abby and Libby takes precedent over right and wrong by officials. And this is why we fight the state. Because this could be any of you. Because if this man is innocent, it could be your innocent loved one. And would this be okay if this was your mother, if this was your brother, if this was your father, if this was you, your child, your grandchild? Would this be okay to you? Thus, in cases involving involuntary confessions, remember, involuntariness would be determined by the fact that he was undergoing a state of mental psychosis, that he was medicated, that he was coerced mentally, psychologically, and physically by the prisoners and the state employees who were communicating with him, possibly threatening him and his life and his family's life, medicating him, distressing him with a physical environment that would naturally tend to do so. This court enforces the strongly felt attitude of our society that important human values are sacrificed where an agency of the government, in the course of securing a conviction, wrings a confession out of an accused individual against his will. The insistence upon putting the government to task of proving guilt by means other than inquisition was engendered by historical abuses of which we are quite familiar. Chambers versus State of Florida, Watts versus State of Indiana, and on and on. Look back to the Inquisition. The truth or falsity of Allen's statements are of no consequence to this analysis. Allen has been treated unlike any other pretrial detainee in Indiana recent history, and that's a fact. I would postulate he's been treated unlike any pretrial detainee in recent national history. He is the Hannibal Lecter of our generation in the way that he's treated. Or put better, he is being treated as the Hannibal Lecter of our generation. Based on what? Bullet extraction marks that are not a proven science? Based on what? Him putting himself in the vicinity of where the girls were later found? Oh, you mean like 25 other individuals that we have identified? Based on what? On him resembling neither of the sketches, who are supposed to be two different individuals, but who now Doug Carter magically says is the same individual. Can we go back and get clarity on that? Why did ISP in 2019 say these are not the same individual? This is a young guy, this is an old guy. This guy's no longer a person of interest, this is a new person of interest. Okay? Two different witnesses describing two different individuals, but now Doug Carter wants you to believe that Richard Allen is both of them. Make it make sense. Make the lies make sense. You go to the website now, and who's the sketch that you see on that screen? It's the young guy sketch. If it was both, why are both sketches not on that fucking screen? You see a video of Bridge Guy, and you see the young guy sketch. If it's true that Richard Allen is both sketches, why do you not go to that ISP or that FBI website? Why do you not see both sketches on that fucking website? You know why? Because that old guy sketch had already been cleared since 2019. So Doug Carter is feeding you a stinking pile of shit when he's telling you that you take both sketches and Richard Allen in the middle, and that's your guy. He's a stinking pile of shit. If it was both sketches, that old guy sketch would be on the website to this date as the person of interest, and it would say both sketches are the same individual. But it doesn't say that, does it? Also, we know it's not, because we remember that Betsy Blair said that she gave it a 10 out of 10 for likeness of that young guy sketch. We also know that the person Sarah Carbo saw was not wearing what the Bridge Guy was wearing. He was not bloody. And that's your old guy sketch. So you make it make sense. Allen has been treated unlike any other pretrial detainee in United States modern history. Take it to the bank. What are they trying to hide here? Are we trying to hide the human trafficking, sex trafficking, meth trafficking, local group that is at the center of something so monumental that no one could ever conceive of how big it is? So Allen's got to go for all of them. Is that why this case is surrounded by former sex workers, madams, pedophiles? Is that why this case is covered by all your fucking sex workers and pedophiles? Is that why we've got a contingent of 50 locals who are behaving as a unified front of a troll farm to keep us from saying the Patty family's names, to keep us from talking about the defense theory of this case, and to basically scare people off of the internet who have any sort of divergent opinion about this case? When you have a suspect who's being treated unlike any other pretrial detainee in United States recent history with Richard Allen. Show me anyone else that's walked around with a shock vest on and bound like Richard Allen is. A tiny man who's no record of any sort of assault against anyone in that jail, anyone in the police department, anyone in the courtroom, no record of him assaulting anyone, and he's walked around like that. Like a modern day Hannibal Lecter. Why do you think that is? The methodology employed by the justice system is one of first impression, and therefore the circumstances created by this methodology should not be a part of any consideration of Allen's guilt or innocence. The system of pretrial detention employed against Allen runs afoul. Yes, it fucking does. It's a constitutional violation, and it could be your loved ones. At any moment, that could be your loved ones. So where's the Constitution when it comes to your loved ones, if it's not there for this guy? It runs afoul of the 5th and 6th Amendments and Article 1, Section 14 of the Indiana Constitution. And I can't put it any better than that. So all of you troll farm can go suck a dick. And all of you good folks who actually give a shit about the Constitution, about the way people were treated, and about true justice for Libby and Abby, and not only those victims, because nothing's going to bring them back, but about what is going on in this county. What is going on with these people where they're doing this to a guy like this? Whether he's guilty or innocent doesn't matter. Whether he was involved or not, it doesn't matter. You look at him. If they had a strong case, none of this would be necessary. Okay, if he did it or if he was involved in it and you got a good case, then you run it with integrity, with transparency, and with the fair, blind balance of justice. You don't do it like this. You don't get a biased judge. You don't get a lying contingent of law enforcement and a fanatical prosecutor. You don't do it this way. And that's bottom line. Anyway, sorry for the rant. But it's frustrating because what can we do? What can we do when all we are outside observers? Okay? We are not the stakeholders here. We're not the powerful people. We are not. We are just civilians here. We're innocent outside observers who know right from wrong. We want justice for Abby and Libby, but we want it the right way. We don't want a local contingent of troll farm, of sex workers, of pedophiles, and of state actors railroading this case and the public narrative around it. That's not what we want. We want true justice for Libby and Abby. And what is that true justice, Prof? Truth coming to light, no matter what it means. No matter what is revealed. No matter who's implicated. No matter what is learned. Truth coming to light is true justice for Abby and Libby. Why? Because no one will ever bring them back. No blood will ever bring them back. You arrest Richard Allen, you convict Richard Allen, you death sentence with Richard Allen. That won't bring them back. You get Garrett Kurtz, you get anyone else, you get Elvis Fields, you get Brad Holder. The blood of no one will bring back Abby and Libby. So what would justice look like? Justice would look like the true story of what happened to those girls. Justice would look like explaining Liberty German's cell phone pings. Justice would be understanding who turned the phone off, who turned the phone back on. Justice would be understanding who put those bodies where those bodies were found. Justice would be knowing, why do the family's statements always seem suspicious and inconsistent? Justice would be seeing the forensic data from all the cell phones of all these parties that were involved and have been alleged to have been involved. Justice would look like an actual investigation with actual answers. Justice could even be found if no one ever goes away for the crime, as long as the true story comes out about what happened to those girls in February of 2017. Whether it's on 1 day, 2 day, or 3 day period. We don't even know how far apart those girls died. Who died first, who died second, who died when, who died where, who died what, who died how. We don't know that. What would justice be? When that book is written about what actually happened, factually happened to those girls in Delphi, Indiana in 2017, so that they are honored by the truth coming to light. And that's the only justice that will be true justice. Now, if people go to prison, if people die because of it, and in the process, then that's fine. That's fine. Perpetrators get blood for blood justice, fine. That's fine. But there's no use in blood for blood or in incarceration if the story's never told. So that is my show for you guys. I appreciate so much the fact that you have tuned in today for this brief overview. Remember, we're going to have tomorrow, we'll go over the next set of documents, and then the next day, we'll go over the next set, and we'll wrap up. After all these days are done with all of these hearings, we're going to do a whole wrap up summary and see where we are then, because what we're going to learn in the next 3 days, okay, we're going to learn where we are. So at this moment, we're just looking at what we're looking at, and it won't be too many days before we know where we are, and then we still have to move forward. So so that's where we're going to be headed. This is going to be an interesting few days. I'll definitely see you tomorrow for more looks, right? More looks. Thanks everyone for being here. I love you so much. I appreciate you. Again, please hit the thumbs up. Please hit the super chat. Hit the buy me a coffee. Hit the Cash App. Hit the merchandise. Hit the share. Hit the like. Hit the subscribe. If you're on the replay, please hit the comment section. I always love hearing everyone's ideas and thoughts after the fact. I love seeing comments roll in. It's a highlight of my day. And I appreciate everyone that's been here in the chat. But keeping the chat going is just, it's so thrilling. It's an honor for me to see everyone engaging in the chat. It's really the greatest compliment you could give is to participate in the chat and show that as a community, you're not going anywhere. And I really do appreciate you for being present in the chat. It's a gift to me that I could not repay. But I thank everyone for being here. God bless you. Now, enjoy the rest of the day with your family. And I'm sure we'll be hearing shortly about some of the results of today. And so we'll kind of keep up with that in the comments. We'll keep up. But God bless you. And we'll see you next time for part 2, where we'll figure out what happens tomorrow. So thanks, everyone. Let me see who's here. We're saying Fort Pitts, thank you for being here. Swade Smith, thank you for being here. So they say, thank you for being here. Lisa, thank you for being here. Shay Watson, thank you for being here. Nobody Nothing, thank you for being here. Sweet Dude Shibby, thank you for being here. Someone times Sweet Dude Shibby out. Please don't ever time Shibby out. He's my buddy. I want him here, so please don't ever time out Shibby. Sandy D, thank you for being here. Fort Pitts, I said hello. Kayla, thank you again, Kayla, for always being here for years. Fair Maiden Wins, thanks for being here. Fur Baby Daddy. Rick H, thanks for dropping in. Rick. Kelly G, thanks for dropping in, Kelly. Who else was here? Oh, Bobby Smith. What's up, Bobby Smith? Thanks for being here. Really appreciate that. Let's see if I can. I want to see who timed out Shibby. I don't see him timed out. Maybe it's a glitch, but yeah, Bobby Smith, thanks for hanging out. Wayward, thanks for hanging out. Bonnie, thanks for being here, Bonnie. Sorry I didn't say hi earlier. Crystal Blue Persuasion, thanks for being here. Diamond Eyes, thank you so much for hanging out earlier. Everyone who was here earlier, Sandy D, Carol, Clumsy Clairvoyance, thank you for being here. Tracy Fleetwood, and everyone else, whoever I haven't mentioned, I know you might have been here much earlier. Thanks so much for being here. I'm sure you're going to see some post-hearing shows. Please go watch those shows and figure out what happened today. I will do so as well. And yeah, man, enjoy your Tuesday. And God bless you. We'll see you later.